Lord Sumption will summarise the judgment of the court.
This appeal arises out of a tragic accident in Germany in 2004. Major Christopher Cox, an officer then serving with the British Army in Germany, was riding his bicycle near his base when a car left the road and struck him, causing him injuries from which he later died. Under the law of the European Union, a claim in respect of the accident may be brought directly against the driver's insurers in the courts of the country where the claimant lives. Acting under these provisions, Major Cox's widow brought the present claim against the German insurer of the driver in the courts of England. It is common ground between the parties that the liability for the accident is governed by German law, and that the driver was indeed liable under German law. This dispute is about damages. Which law applies to them, German law or English law? It is an important question because English and German law on damages for fatal accidents are in some respects very different. In German law, Mrs. Cox is entitled to the damages which she has suffered by losing the benefit of her late husband's legal obligation to maintain her financially. Against that, she must give credit for any maintenance that she may have become legally entitled to receive from a subsequent partner. Mrs. Cox currently has a new relationship with a man to whom she is not married, but with whom she has a child and who is for that reason legally obliged to maintain her. Does she have to give credit for what she receives from him? In German law, yes. Under English law, however, most aspects of damages are governed by the Fatal Accidents Act 1976, which is the sole basis on which English law allows a claim for damages for the death of another person. This provides that a widow's maintenance from a subsequent relationship must be ignored, and that credit need not be given for it. In addition, under the English statute, a widow is entitled to a lump sum fixed by statutory instrument representing her non-financial loss, essentially the suffering caused by her husband's death. Under German law, by comparison, she can only recover damages for her suffering if she can show that she has suffered a mental or psychological illness. In both of these respects, English law is significantly more generous to a widow in Mrs. Cox's position than German law is. Hence, the importance of the question in this case, which law applies. Under a rational system of law, since this was a German accident occurring in breach of German law, Mrs. Cox should get exactly the same, no more or less, than she would have obtained from a court in Germany. That is, in broad terms, what the law has said in England since 2009, when the relevant English statutes were amended as a result of an international treaty, the Rome II Convention on Private International Law. However, this accident occurred in 2004, when the law was more complicated. Under the law as it stood in 2004, the normal rule was that it was necessary to distinguish between questions of substance, which are governed by the law with the closest connection with the accident, in this case German law, and questions of procedure, which are governed by the law of the court hearing the case, in this case English law. Questions of substance governed by German law included what kind of damage was recoverable, what was the scope of the duty which the driver broke, what loss might be said to have been caused by the breach of that duty, and what deductions must be made to reflect the fact that loss may have been successfully reduced or avoided by the claimants. Questions of procedure governed by English law include the assessment or computation of those categories of loss. There are essentially two issues for the Supreme Court to decide. The first is whether the normal rule of English law applies. Mrs. Cox's case is that it does not apply, because the damages rules in the English Fatal Accidents Act apply to accidents wherever they occur and not just to those which happen in England. The second question is whether, if the normal rules apply, the damages rules in the Fatal Accidents Act are rules of substance or procedure. In other words, whether they are rules about the kind of damage which is recoverable or rules about the way in which those are to be assessed. The Court of Appeal held that the relevant issues about damages were all governed by German law. The Supreme Court unanimously upholds that decision, although for somewhat different reasons. On the first question, the Supreme Court holds that the damages rules in the Fatal Accidents Act apply only to claims brought under the Fatal Accidents Act itself, in other words, only to claims where liability is governed by English law, not to claims where liability is governed by a foreign law. There are some cases in which an English court is required to apply English law, even to a wrong committed abroad, as a matter of policy. This may happen if the relevant English rule is derived from a statute which can only sensibly be given effect if it applies internationally. It may also happen on the grounds that the relevant English rule represents a fundamental policy of English law, so important that an English court can be expected to apply no other, or indeed on the ground that the alternative is a foreign rule of law which is regarded as repellent to basic concepts of justice. The Supreme Court considers that none of these rather special situations exists in the present case. There is no reason to believe that Parliament intended the Fatal Accidents Act to apply to the consequences of a motor accident in Germany, and there is nothing repellent or indeed unusual about the German damages rules. Indeed, the German damages rules are much the same as the rules which apply in England to everything other than fatal accidents. Turning to the second question, the Supreme Court holds that in every respect which is relevant to this particular case, the German damages rules are rules of substance and not rules of procedure. This is essentially because they are rules which determine the scope of the relevant duty and which answer the question what losses must be taken to have been caused by a breach of that duty. It follows that Mrs. Cox's damages claim must be decided in an English court in accordance with German law and that her appeal must be dismissed.